Hey there. Today we're going to talk about copyright and copyright protection and the Bartz v. Anthropic AI lawsuit. This is something that a lot of writers have been very interested in, and we're going to talk all about it today. And there's going to be some math and some legalese and all kinds of fun stuff. And if you're a writer, stick around till the end because I'm going to show you how to file your claim in this lawsuit. So stick around and let's get all legally on it. Hey there, welcome back to the channel. I'm John Hartness. I'm the founder and publisher of Falstaff Books and the author of 42 novel-length works, including Quincy Harker Demon Hunter, Bubba the Monster Hunter, The Black Knight Chronicles, and multiple others. And out of all of those books that I've written, I found 7 of them are on the works list for the Bartz v. Anthropic lawsuit. So some of you have heard about this suit brought by multiple authors and expanded into a class action suit against an AI company that pirated millions, literally millions of books, and used it to train its AI model. So we're going to talk about a bunch of stuff having to do with this case, and then I'm going to cut away and show you step by step exactly how to go through and file a claim. But first, go ahead and subscribe so you can get all of my writing content and all kinds of other awesomeness that we do here. So, Bartz v. Anthropic. What is it? And this is coming straight from the authorsguild.org website, and we'll put a link in the description to this so that you can go read all about it yourself. But here's what's on the Authors Guild website as the background of this suit. Bartz v. Anthropic is one of the major copyright lawsuits brought by authors against an AI company for using books without permission to train large language models. It was filed by nonfiction authors, and pardon me if I butcher these names because I don't know any of these people and I may screw it up. Charles Graeber, The Good Nurse, and Kirk Wallace Johnson, author of The Feather Thief, and thriller author Andrea Bartz, author of We Were Never Here. In June 2025, Judge William Alsup of the U.S. District Court for the Northern District of California ruled on summary judgment that using books without permission to train AI was fair use if they were acquired legally. This is actually huge because this means that as long as a company buys a copy of the book, they can use it to teach their AI how to copy your style. I am not a judge. I am not an attorney. All of my legal knowledge comes from, I don't know, decades of watching Law and Order and reading police procedurals. So don't take any of what I'm saying as legal gospel or advice, for God's sake. This sounds like BS to me, because using my work to train a computer system feels like it's still a violation of the agreement that we're engaging in when I sell you a book. But now there's an actual legal ruling that says as long as they've paid for the book, they can use it to train their AI to rip off your style. I think that sucks. I'm still very staunchly AI. Yes, I can hear the dude bros typing in the comments about how AI is here to stay and I'm a Luddite and I should just embrace change. Well, suck it, all right? I hate this crap. It is theft. It is built off the back of my work. And if you don't like that, there's a whole lot of other channels on YouTube. Back to the case. But Alsup denied Anthropic's request for summary judgment related to piracy, finding that the piracy was not fair use. Judge Alsup scheduled a trial to determine Anthropic's potential liability for piracy for December 1, 2025. In July, the court certified a class of all rights holders of books Anthropic acquired from LibGen and I have no idea how you would pronounce this, but it's PILIMI, provided the books were registered with the U.S. Copyright Office in a timely manner and have ISBN or ASIN numbers. Judge Alsup certified the class only for piracy, not the act of AI training, and as such, the fair use ruling on training applies only with respect to the three named plaintiffs, not the certified class authors and publishers. The proposed settlement agreement came after an arm's-length mediation with a neutral third-party mediator. The settlement agreement was preliminarily approved by Judge Alsup on September 25th, 2025. I looked up what a arm's-length mediation is, and that basically just means that no one involved on either side of the case has any contact. They're not related, they're not in business together, they don't know one another, and they are each all acting in their own best interests with the neutral third-party moderator. What we know today, kinda. Again, all of this is coming from Authors Guild, and there's a problem that I'm about to point out with what's on the Authors Guild site. The settlement that has been approved was $1.5 billion, and that's to be split among the rights holders of all of the books included in the class after admin fees, lawyer fees, and expenses are paid. And each title is paid an equal amount. The settlement agreement discloses that approximately 500,000 titles are in the class, after accounting for duplicates and non-eligible works. That means that after attorney fees and other expenses are deducted, rights holders can expect approximately $3,000 total per title, which will be shared among the rights holders for that title. We'll get into that in a little bit. But here's the problem. That math don't math. Because, yes, in fact, 500,000 books times $3,000 does equal $1.5 billion. And does not cover any of the attorney fees, administrative expenses, or anything else that the lawyers are going to enrich themselves with. And look, I'm not going to say that the lawyers don't deserve to get paid, because they do. The Anthropic website, there has obviously been hundreds of hours of work put into discovery on this case and writing briefs and arguing and all that. And just the back end alone to figure out what books were pirated took weeks and months of people working and searching databases and coding crap to build settlement websites. The lawyers should get paid. But we ain't all getting $3,000 a book. Because if there's 500,000 books and there's 3,000 and there's $1.5 billion in the settlement, well, that doesn't leave anything for the lawyers. And we all know the lawyers are getting most of the money. So that says to me that we will all be lucky if we get maybe $1,000 per title. That's not great. What's less great is that that's 500,000 titles out of 7 million books that were stolen. Why are there only 500,000 books included in this class, John? I can hear you asking. Well, because of the way copyright works. Now, a lot of people do not understand much about how copyright works. And this includes a whole lot of people in publishing. And the publishing industry changes rapidly, but the law does not. And there have been lots and lots of things out there that purport to offer copyright protection. Unfortunately, that is not accurate. The only way that you may bring a civil action against someone who infringes on your copyright is if you have registered the work with the U.S. Copyright Office. This is enshrined in federal law as part of Title 17, which is the part of the United States Code that covers copyright. And it sucks, because even though Title 17 also states that copyright is in effect from the moment something is fixed in a form, you can't bring a civil action unless you register the copyright with the Copyright Office. I don't think this is right. I don't think this is fair. I think that if someone steals your shit, you should be able to sue them for stealing it, because obviously they're not going to be able to file criminal charges. Although I think that there may be criminal charges for piracy as well available for this work. But at the end of the day, that means that 6.5 million books were stolen that nobody's getting any compensation for. And the $3,000 that everyone has been bandying about on the internet as a figure is not possibly correct, because the math ain't mathin'. Because if there's 500,000 titles and there's $1.5 billion, that's $3,000 per book. You know the lawyers are taking, I'm guessing, 2/3 of this, and that's just me doing cocktail napkin math. I don't know how class action lawsuits work. I know that I've only ever gotten, the most I've ever gotten when I get those letters in the mail saying you may be eligible, I think the most I ever got out of it was $11 or $12, but whatever. Now, this does not mean that you get it all, because if you're working with a publisher, there is a split written into the settlement to split that money 50-50 between the author and the publisher. Why does the publisher deserve a piece of this money? Well, because if Anthropic had bought the books, the publisher would be getting a piece of the money, because the publisher has the right to distribute the book. That's what publishers do. We distribute books. So it is perfectly reasonable that if you're getting paid because your stuff was pirated, that you should split that between the author and publisher. And there's a default split set in the documentation that cuts that right down the middle, and you can opt out. If you have a different split built into your contract, you can do it that way. But here's something that's very important for you to know. If you are an author with works in this list, and coming up when we cut over to the screenshot, I'll show you how to search the list. If you've got books on the list, you must either file a claim or proactively opt out of this suit. If you do nothing, then you will waive your claim against Anthropic and will neither receive money nor be entitled to sue them separately. If you want to sue them separately, you have to opt out of this class action. But if you or someone that you are their heir or you manage their literary estate or your publisher, if no one files their claim and does not opt out, you ain't getting paid. So make sure that, let's say, maybe your grandfather wrote a best-selling novel and it was pirated. Well, go on the list, look it up, see what's on there, see if Grandpa's memoir was pirated, and then make sure to either file a claim or opt out. Now, what are some important things to keep in mind about this? One, this is a huge deal. Not only does this mean that authors are getting a little bit of their money back and making this AI company feel the sting a little for stealing stuff, it also sets precedent for perhaps suing other big-ass AI companies, because now these guys are paying it. What about the next guy? So it means that either these companies are going to have to find some other free way to train their large language models, or they may have to actually buy the books that they want to train their model on. And look, we have a guest star. This is Daisy. Hello, sweetheart. Daisy likes to chew on ink pens, don't you, girl? But she's my pretty girl. And she loves being picked up and held at least as much as her brother does. You did knock my microphone right off onto the floor. Come on, sweetie. You want to chew on my pen some more? Yes, I do. Yes, I do. Yes, she's the prettiest girl, but she is pretty good about putting that tail right on the camera. So that's a rundown on the Anthropic lawsuit and what it is. Now let's cut away to a screen cap where I walk you through the process of filing a claim, and I explain a little bit about what it means to be a sole or beneficial or legal owner of a work. So I'll see y'all back here in a minute. Okie dokie. Here we are on the Anthropic Copyright Settlement website. If you are the legal or beneficial copyright owner of a book included in the settlement, this is where you go. It is anthropiccopyrightsettlement.com. We've got a link down in the description. And you've got all this stuff up here, important documents, FAQ. These are the two things that we care about: the works list lookup and filing a claim. Now, I really recommend that you open a separate tab and you open this form, this website, in each tab. That way, instead of typing in works list lookup and typing in a bunch of stuff and then going to file a claim and all that, you can just click over onto the tab where you've looked up your books and then click over onto the tab where you want to file your claim. So here on the Anthropic Settlement website, the first thing you do is you click on Works List Lookup and figure out how you want to search. If you have your ISBNs, if you have your title, most of the time it's probably going to be easier just to search on your name. Boom, there we are. So you've got your works list. You'll notice that they returned a false positive here. I'm not John Hartnett. I never wrote anything about dismantling the Big Bang, and I have no idea what New Leaf Publishing Group is, so I won't file a claim on this. I will, however, file a claim on these other 7 books. You'll notice that this is not the full list of 185 books that I had in the initial settlement list. That's because there were some duplicates, there were some things that were not fully registered with the Copyright Office, and some things may have been found to not have been actually pirated as part of this case. There's a specific window of time that things had to be stolen, and there's a lot of criteria, and you can go right here in FAQ 49 and read up on how the works list was created. But this is the list of my books that are in here. We've got 7. So now, how do I file a claim? I want to keep this list open, so I will go back to the main page and click the File a Claim book link. Lord. That will take me here, where you input your claimant information. Now, I've already filed my claim, so I'm just going to plug a bunch of BS information in here. But it's all very simple. This is your legal name. This is the name that it's all registered to. And then if you have a company name and a title, fine. If you have a pen name, fine. These are not required. The things that are required are the things with the asterisk, just like on every other internet form you've ever filled out. You do have to enter a real email address. Don't use your throwaway email that you use on things where you don't want spam, because they're going to have to communicate with you. And then for most of you, if you are a self-published author, you are filing this claim as author. If you're self-published, don't fill out as publisher, because it might not match. Your name might not be what matches here. You'll see that these 2 list as being published by CreateSpace Independent Publishing Platform. That's not quite correct. That's probably who I used the free ISBNs by, but doesn't really matter, because CreateSpace isn't going to be filing a claim, because CreateSpace as a company no longer exists. So they're not going to be filing a claim for half my money. So once you're here, you fill out that you're the author, and then you come down here and are you a director, officer, or employee of Anthropic, PBC, blah, blah, blah. This is required. I don't know if this makes you ineligible to file a claim. Consult someone who knows way more about law than I do. I just know how to fill out an internet form, and I am not any of these things, so I clicked no, and then I clicked next. And then we go right here to the works information. I've already filled out the first one of these. This is all really straightforward, y'all. There's no reason it should really hang anybody up. The only part where it may be confusing is right here, where are you the sole legal/beneficial owner? See FAQ 8. Boop. What is a legal owner? What is a beneficial owner? What is the sole owner? A legal owner holds the right to publish and reproduce that work. Often by contract, the legal owner of the work is the publisher, because it holds the right to reproduce by contract. A beneficial owner of a book is a former legal owner who assigned the exclusive right to publish and reproduce the book to another in exchange for royalty payments. Often authors are beneficial owners. A sole owner holds all rights to reproduce the book. Examples of sole ownership include an author whose rights in the book have reverted from the publisher, an author whose rights assigned to the publisher have terminated. This is like if you had a limited time that the publisher had the rights. If you were in an anthology, for example, and they had an exclusive period of time in which they could publish the book, and then they could only publish it that one time. Let's say you were included in World's Best Horror 2020. Well, they had a one-time shot to publish that. So for that story, you are now the sole owner. For that anthology, there may be multiple legal owners. And then a self-published author, which is going to be a lot of y'all, a self-published author who didn't work with a co-author and never assigned rights to a publisher, or a publisher that commissioned work for hire as defined in the Copyright Act, or a publisher to which all rights in a book have been assigned with no royalty obligations to an author or anyone else. I don't know why any author would do this last bit, but I am sure that it happens. But work for hire happens all the time, and most work for hire, you don't control any of the copyright. But for most of y'all, you're going to fall in right here as a self-published author, or you're going to be the beneficial owner. So we'll go right back here. Are you the sole legal beneficial owner? No, I am not. I am the beneficial, what did I say? I am the beneficial owner because I am the author. Bell Books is the legal owner because they are the publisher and they have been assigned the right to publish and reproduce the book. Now on my title, Damnation, I am the sole legal and beneficial owner because I am both the author and I own the publishing company. Other authors that I publish with Falstaff, if they have books that are eligible, they would put no here. But since I own the publishing company and it is a single member LLC where I don't have partners that also own part of the company, I am the sole legal and beneficial owner. For other works that I publish, I am the legal owner, not the beneficial owner and not the sole owner. And then you also decide, select whether or not your book is listed as an education work or not. But this will be also on your education work column in the lookup. But this is really all it is. You literally just fill out everything on the works lookup page. Sorry, wrong page. You fill out all of this stuff, and the only thing that you might get hung up on is, are you the sole legal or beneficial owner? And then when you type that in, you add another, and then you add another, and then, depending on the number of stuff that you've got going on, you may have to do this a whole bunch of times. But it's just cut and paste. This is really the only question that I had when I was filling this out, and I read the FAQ and it made sense to me. But I also called a friend of mine who is another publisher, and she and I talked through it, and with what she has read about this and with what I have read about this settlement, that's where we came to. There may be questions about the legal and beneficial ownership of a work if your rights reverted, but if they had not reverted during the time of the infringement. I don't know the answer to that. For me, none of my stuff with Bellbridge has reverted at this time, and all the other stuff I own the company, so I don't have to worry about that. You'll need to consult someone if you had a book that was under contract with a publisher during the time of the infringement, but it has reverted subsequent to that, but before you're filing the claim. You'll have to ask someone, and I don't really know who to ask, but I bet I would start with this phone number right here and or this email address right here, because I would be talking to these folks because it's their job to figure it all out. So this is also where you can go to get all the information that you need. And again, that website is anthropiccopyrightsettlement.com. So there's just a quick walkthrough of the settlement form, and now we'll go back to the studio. And okay, we're back. And by we, this time I do mean me and Daisy. She's still right here. So I hope you see that the claim process is pretty straightforward and fairly simple. But there's nothing simple about a giant class action lawsuit with 500,000 or more moving parts. So you have to file your claim in 2025. I believe the cutoff is November of 2025. And they currently are scheduled to begin payments in June of 2026. We'll see. Not sure if there are going to be any kind of appeals or further legal wrangling. This is a settlement that was mediated and signed off on by the judge. So hopefully this part is a done deal. I don't know what this means for the future of AI. I don't know what this means for the future of copyright law or piracy deals or any of that. What I do know is that a whole lot of people are going to be rushing the Copyright Office every time they publish a book. And I also know that I have reached out to my congresswoman to work on trying to get Title 17 changed, because in the digital age, we should be able to prove ownership of a title with an ISBN or an ASIN, and that should be enough. I shouldn't have to pay $75 and mail hardcover books to the Copyright Office. So Title 17 should be updated to reflect the digital world that we now live in. But we'll see if I get anywhere with that, or if anybody else does. I also don't know if there is a potential for another ruling from a different judge about whether or not this is fair use. The Authors Guild sites indicated that only the 3 specific claimants, the 3 authors who brought the suit, were the ones that were specifically affected by the fair use ruling. That seems to mean that other people could make another case that training your large language model on my work is not fair use. The current ruling, the current judge says that it is transformative enough. Well, I don't know if I buy into that, because I have done some experimentation with some of these large language models and some of these AI things, and I've specifically said, write something in the style of this author. And it can steal style fairly well. There's still a bunch of different stuff in it that makes it obviously AI and obviously not touched by human creativity. But since it is that derivative, I believe that it's not transformative enough. Now the question is, where can we find a judge that is technically savvy and literature savvy enough to agree with that? I don't know. I don't know if there's a lawyer out there that's willing to tilt at that windmill with me. But this is not dead. This is not over and done with. There's a lot of moving parts to this, and it's a developing technology in a developing world. So there's a lot to keep an eye on, and as I learn more, I'll share it with y'all. If you know more than I do, and by know more, I mean legit know more. If you just think or speculate, well, that doesn't really do us any good, does it? Then you're no more of an expert than I am. And I am far from an expert on AI. So if you know something, comment it. If you don't, comment anyway. Tell me what you think. Tell me if you're an author that has works that are part of the process. Tell me if you're an author that's opting out of this class action lawsuit. I'd love to hear your thoughts on that. And otherwise, I'll see you guys next time. And remember, if you want to get these videos a little early, you can become a member of the site, like all of these people that are listed on the screen right with me. So thank you all for your support. And the rest of you, thanks for watching. I'll see you next time.